Welcome to the Sexual Harassment Prevention Training for District Employees covered under Mayor's Order 2023-131. The district recognizes the impact discrimination and harassment has on employee morale, productivity, and long-term success. Harassment, particularly sexual harassment, has the effect of unreasonably interfering with a person's work performance and creating an intimidating work environment impacting the health and safety of all. The district is providing this training to help ensure a workplace free of harassment for its employees and customers, and to ensure that all employees are trained on Mayor's Order 2023-131. The modules that will be covered in this course are recognizing sexual harassment, maintaining a harassment-free workplace, reporting sexual harassment and misconduct, and ending with prohibited relationships. Module 1. Recognizing sexual harassment. In this module, we'll define and discuss sexual harassment and misconduct under Mayor's Order 2023-131. Sexual harassment is defined as any conduct of a sexual nature that constitutes harassment, which is conduct that is direct or indirect, verbal or nonverbal, that unreasonably alters an individual's terms, conditions, or privileges of employment, or has the purpose or effect of creating an intimidating, hostile, or offensive work environment. This includes quid pro quo sexual harassment, which is sexual advances, requests for sexual favors, or other conduct of sexual nature, where submission to the conduct is made either explicitly or implicitly a term or condition of employment, or where submission to or rejection of the conduct is used as the basis for an employment decision affecting the individual's employment. Points to note. Point 1. There need not be a specific number of incidents nor specific level of egregiousness for conduct to be considered sexual harassment. Point 2. Conduct need not be severe or pervasive. And point 3. Any conduct of a sexual nature may be treated as misconduct, even if it does not rise to the level of sexual harassment under the law. Now, who is covered under the Mayor's Order? Mayor's Order 2023-131 covers employees, contractors, fellows, interns, grantees, and customers, clients. The victims and harassers can be people at all levels of an organization, people of any sex, and non-employees. Here are some examples of misconduct that are prohibited under the order. Sex acts. An example: an employee and a grantee were found having sex in a supply closet. Display of sexual organs. This is the case where a contractor flashed their genitals to a fellow contractor in the hallway on their way to the restroom. Sexually offensive comments or off-color language, jokes, or innuendo. For example, before a team meeting, an employee and contractor were chatting about their weekends in front of others. The contractor made a joke about spending the weekend with the employee's mother. And sexting. A supervisor texts their subordinate about an urgent work deliverable. Since then, the subordinate has sent the supervisor several photos wearing lingerie, claiming each one was by mistake. Here are more examples of misconduct. An employee jokes that if they weren't married, they would try to hook up with the agency's summer intern. An employee walks into an all-staff meeting. Their teammate slowly looks them up and down as they walk towards their seat. An employee asks a contractor, whom they befriended, their opinion of a gift. The employee sends the contractor a link for a sex toy. A term employee is approaching the end of their term. During a one-on-one meeting, their supervisor tells them that they will extend their term if they can take them out to dinner. At a team happy hour, an employee asked their non-gender conforming colleague how they have sex. An employee forgot that their camera was on during a team meeting. The employee is observed masturbating on camera. An employee is walking through a narrow space filled with people at a work event. They grab another employee's waist as they move through the space. A subordinate continuously asks their supervisor to get drinks after work, despite being refused each time. A grantee leans over an employee's desk to explain some work material. A contractor takes a photo from behind when the grantee isn't looking. And lastly, two employees are having a conversation. A third employee comes up behind one of them to join the conversation and begins to rub their shoulder. Impact on the workplace. Some negative impacts: high anxiety, physical and psychological illness, avoidance and discomfort, reduced productivity, absenteeism, and potential litigation. Impact versus intent. What if you didn't mean to offend? How your actions are perceived by others and the impact they have on those persons are the things you need to consider when evaluating your behavior. Ask yourself, what impact could my behavior have on others? Whether or not the conduct is intended to be harassing is generally not relevant to determining whether sexual harassment has occurred. Remember, actual intent is irrelevant. "I was just joking" is not a valid defense. Knowledge check. Case Study 1. An employee, Jane, is regularly asked by her coworker, Joe, to go out for drinks after work. The invitations are never more than simply an invitation. Jane has always politely declined with phrases such as, "not today," "maybe next time," and similar refusals. The repeated requests have started to make her feel uncomfortable. Jane has not formally reported Joe's conduct, but shared her discomfort with her teammate, Dylan. Is this harassment? The answer: this scenario should be looked into further by a sexual harassment officer, even if it does not initially seem like it requires a full investigation. The conduct, while not overtly sexual, could be interpreted as harassment depending on the specific facts. The conduct makes Jane uncomfortable and could potentially contribute to an intimidating work environment. At minimum, the agency will need to notify Joe that the conduct is unwelcome and must stop. Let's add on more layers. Joe invites all his coworkers out for drinks every 2 to 3 weeks for happy hour. Not everyone attends each time, but most coworkers go regularly. All other behavior by Joe is appropriate. He just likes to socialize with his coworkers after work. In this scenario, Joe's invitation is not directed towards any specific employee. Jane is uncomfortable with Joe's invitation and is not comfortable escalating the situation. Dylan, who is aware of Jane's discomfort, can speak to Joe to get the behavior to stop if he's comfortable doing so. If he's not comfortable speaking to Joe, he can share the issue with his supervisor and/or agency sexual harassment officer. The agency should take action to get the invitations to Jane to stop. Knowledge check. Case Study 2. Alex, a grantee, comes into the office at least once every other day for meetings. Alex takes a liking to the executive assistant, William, and asks him out once. William is not interested and says no. Since then, at least once a week, Alex brings William candies, flowers, cards, and small stuffed animals as gifts. William continuously tries to refuse these gifts. Is this harassment? The answer: yes. William can either tell his supervisor or sexual harassment officer about Alex's behavior. If the supervisor notices the activity without being told by William, the supervisor also has an obligation to act. An agency representative must speak to Alex and make clear that the behavior is not welcomed by William or by the agency. Alex should be reminded that as a grantee, she is subject to the district's sexual harassment policy and must cease her unwanted behavior. More layers. What if Alex and William are the same sex? Remember, the sex of the harasser and the victim is irrelevant for the purposes of sexual harassment. The conduct is sexual in nature and unwelcome. It is harassment and should be handled as such. Knowledge check. Case Study 3. There is some downtime after an all-staff meeting. Although they cannot be heard from outside of the conference room, the group is having a boisterous conversation. The group makes crude, sexually based jokes, insults, and jibes. This happens after just about every meeting, but no one from the team ever complains. Is this harassment? The answer: this behavior may contribute to a hostile workplace and may be considered misconduct, as comments that a reasonable person would consider to be of a sexual nature are prohibited. The supervisor should immediately talk to the team and let them know the behavior must end and further conduct like it will result in discipline. With the help of the agency HR and General Counsel Office, the supervisor should coordinate a group training session on sexual harassment. The team should be reminded that under no uncertain terms such conduct will not be tolerated, and that the continued misconduct should be reported to the supervisor or a sexual harassment officer. As the supervisor, you should inform the team that if such behavior continues, there will be a prompt investigation into the matter and appropriate discipline taken. More layers. Your associate director joins the rest of the team during these conversations and also makes off-colored remarks and jokes. This adds an additional challenge for you for navigating this issue, as the associate director is your direct supervisor and is part of executive leadership. You will need to notify your agency sexual harassment officer about this behavior. Your associate director's behavior could result in considerable liability for the agency, as the associate director's actions appear to condone activities that could contribute to a hostile work environment. If you are not comfortable speaking with your agency sexual harassment officer, report the conduct to another agency sexual harassment officer. You can find the list of agency sexual harassment officers at dchr.dc.gov/page/sexual-harassment-officer-list. As we conclude Module 1, we've gained valuable insights into defining and recognizing sexual harassment in the workplace. Acknowledging the importance of fostering a respectful and inclusive environment is the first step towards a healthier workplace. Now, let's transition into Module 2, where our focus shifts from identification to proactive measures in maintaining a harassment-free workplace. This is crucial in building on our foundation and ensuring the well-being of all employees and customers. So, without further ado, let's delve into Module 2 and explore the strategies and practices that contribute to a positive and respectful work environment. As we think about how to contribute to a positive and respectful work environment, we have to ask the question: who's responsible for preventing sexual harassment? The answer is everyone. As government employees, we are all responsible for refraining from, preventing, and reporting sexual harassment. Let's break this down into 3 areas: agency responsibilities, supervisor responsibilities, and employee responsibilities. As an agency, it is important to facilitate compliance with the district's sexual harassment policies by complying with the district's sexual harassment policies, ensuring a respectful workplace free of sexual harassment, ensuring reports of sexual harassment are taken seriously and are investigated, ensuring the safety of victims, and ensure that the accused are provided with sufficient due process, and demanding that misconduct and unwanted behavior cease immediately. An employer is liable for sexual harassment in the workplace where it or its agents or supervisory employees knew or should have known of the conduct unless it took immediate and appropriate corrective action. Same applies for acts of sexual harassment by non-employees in the workplace. While we all need to prevent sexual harassment, supervisors and managers are held to an even higher standard. Supervisors must take immediate and appropriate action to stop any harassment reported to them or any misconduct they observe. Such appropriate action includes reporting all allegations of sexual harassment to the agency sexual harassment officer. A person in a supervisory role is responsible for any harassment or discrimination that they knew about but failed to take appropriate action to stop, or that they should have known about with reasonable care and attention to the workplace for which they are responsible. Supervisors should model appropriate workplace behavior and take particular care to avoid conduct that could lead to allegations of sexual harassment. Consider time, place, and circumstances of your interactions with employees. Supervisors should ensure employees feel safe approaching them with concerns. Supervisors should not misuse the authority they have been given. Be trained and knowledgeable about the district's and your agency's sexual harassment policies and procedures. Act promptly in response to potential sexual harassment misconduct. Communicate any reports of sexual harassment to a sexual harassment officer or your agency's general counsel. Protect employees from retaliation for reporting sexual harassment, misconduct, or for supporting a victim of sexual harassment. Keep information confidential. Do not encourage gossip. Document all reported incidents and efforts undertaken to take prompt action, and comply with district sexual harassment procedures. As an employee, it is important to know and comply with sexual harassment policies and procedures, including refraining from engaging in sexually harassing conduct, prohibited relationships, and behavior that may cause others to question whether government services to customers, clients, contractors, grantees is provided fairly and without harassment. Complete annual sexual harassment training and confirm your agreement to comply with Mayor's Order 2023-131. Know your agency's sexual harassment officers and report instances of sexual harassment. Cooperate fully in an inquiry or investigation into alleged violations of Mayor Order 2023-131. Other than alleged victims, employees who decline to participate in a sexual harassment investigation after a direct request by the agency to do so may be subject to discipline. Know your agency designee and when relationship disclosure is required. Prohibited relationships, described later, are not permitted and therefore should not occur in district government. Disclosure of permitted relationships may be required where a change in circumstance may cause the once permitted relationship to become prohibited. As we continue to navigate through this course, we've addressed key aspects of creating a respectful and harassment-free workplace environment. In Module 1, our focus was on recognizing sexual harassment. We defined and discussed sexual harassment and misconduct under Mayor's Order 2023-131. Laying the groundwork for understanding the impact of these behaviors on employee morale, productivity, and long-term success. Building on this foundation, we transitioned into Module 2, where we explored the responsibilities of agencies, supervisors, and employees in maintaining a harassment-free workplace. And now, as we step into Module 3, our focus shifts to reporting sexual harassment and misconduct. It is not just about identification and prevention, it is also about knowing how to respond to and how to report sexually offensive behavior. In this module, we'll equip you with the knowledge and tools needed to take appropriate actions, ensuring the health and safety of all. Let's continue this journey, connecting the dots between recognition, prevention, and response to foster a workplace culture that values respect, inclusivity, and the well-being of everyone involved. So, what do you do if you're being sexually harassed? If you see others being harassed, or otherwise know of sexually offensive behavior in the workplace? Ignoring the situation will not solve the problem. The first question is, what can you do? If you feel comfortable doing so, talk to your harasser. 1. Be calm, direct, and specific. 2. Speak with them in private. And 3. Make it clear that their behavior is unwelcome. If you do not feel comfortable approaching the harasser, or the harasser ignores your request, seek help by reporting the misconduct to a supervisor or manager, the agency general counsel, or a sexual harassment officer from your agency or another agency. The list of agency sexual harassment officers can be found at dchr.dc.gov/page/sexual-harassment-officer-list. Anyone can report sexual harassment. Employees, contractors, grantees, interns, trainees, customers, clients, and everyone else all can and should report sexual harassment to a sexual harassment officer or agency official. Note: reporting sexual harassment to your agency sexual harassment officer is not the only option you have to report and address the misconduct. It is just one of several options. For example, individuals may also report a sexual harassment claim within 1 year of the alleged harassment to the Office of Human Rights. They may also file a complaint with the Federal Equal Employment Opportunity Commission, file a grievance under an applicable collective bargaining agreement, and/or report allegations of criminal misconduct to law enforcement such as the Metropolitan Police Department. Keep in mind, reporting sexual harassment to your agency or sexual harassment officer is not the same as filing a formal complaint with other entities such as the Office of Human Rights, and it does not pause or delay applicable deadlines for filing a complaint with these other entities. What happens after you report misconduct to the agency? The appropriate agency sexual harassment officer will receive, document, and investigate the allegations of sexual harassment. Absent unusual circumstances, the sexual harassment officer will complete the investigation within 60 days. The investigation will include fact gathering, which consists of steps such as interviewing witnesses, collecting documents, and other steps, and reviewing the evidence to determine what happened. In some instances, for example, where the conduct is undisputed or easily confirmed, the sexual harassment officer may conduct an expedited or limited investigation to close out the matter even sooner. Note: allegations of sexual harassment against the mayor, city administrator, mayor's senior staff such as the chief of staff, advisors, and directors, deputy mayors, or any official directly reported to the mayor will be referred to the Inspector General for appropriate review and investigation. The rights of the alleged harasser. Individuals accused of sexual harassment deserve the full protections afforded to them under the law in administrative matters, including the right to be notified of the sexual harassment allegations and to respond to the allegations, the right to have counsel or other representation, such as union rep, so long as this does not unduly delay or negatively impact the integrity of the investigation, and the presumption of innocence unless there is a finding of harassment after an investigation is conducted. Note: the right to counsel does not include the right to have counsel paid for by the government. Employees must cooperate fully in an investigation of a workplace complaint. Employees who refuse to participate in a sexual harassment investigation after a direct request to do so may be subject to discipline. If the refusing employee is the alleged victim, the agency must consult its general counsel or the mayor's office of legal counsel before recommending disciplinary action. Employees who make materially false statements, misrepresentations, or falsify or hide material facts or records may face discipline up to and including termination. Pending the final resolution of a sexual harassment complaint, agencies may take interim remedial actions to prevent the alleged harassing conduct from continuing and to protect the rights of the alleged victim and alleged harasser. These actions are temporary, are not disciplinary actions, and should not result in loss of pay, demotion in title or responsibility, or other loss of employee benefits. Some examples of interim remedial actions that are not disciplinary are transfers, changing shift, duties, duty station, or reporting requirements, and administrative leave with pay. Once the sexual harassment officer concludes their investigation, the agency director and/or general counsel will review the facts and results of the investigation and issue the agency findings and conclusions. The agency findings and conclusions will be provided to the complainant and the alleged harasser, and will confirm whether the sexual harassment allegations were substantiated or not. Confidential information disclosed as part of the investigation or personal actions taken because of the agency's findings will not be disclosed to individuals who do not have a need to know. If a sexual harassment claim is substantiated, appropriate disciplinary action will be taken against the harassing employee. If the harasser is not a DC government employee, such as a contractor or customer, the agency will take appropriate action to stop the harassing behavior by terminating the contract, banning the visitor from the worksite, and other similar measures. Here are some things to remember during and after an investigation. If you are involved in the investigation of a sexual harassment complaint, please respect the sensitivity of the matter, the parties involved, and the workplace in general by not engaging in unnecessary gossip. This is especially important while the investigation is still pending to protect the integrity of the investigation. The sexual harassment officer and agency officials involved in the process will keep complaints of sexual harassment and information provided during the investigation confidential as much as possible. However, confidentiality is not absolute because the sexual harassment officer will need to disclose information in furtherance of the investigation. For example, the sexual harassment officer will need to provide the alleged harasser with an opportunity to respond and to parties with the need to know, such as the agency general counsel and director. Agency officials such as the general counsel and director will also have an obligation to report information to the mayor's office of legal counsel, work with human resources and management to issue discipline, respond to court orders for release of records, disclose criminal conduct to law enforcement, and other similar steps. Retaliation is strictly prohibited. Employees should not be punished for reporting or filing a claim of sexual harassment, assisting others in reporting or asserting a claim of sexual harassment, opposing sexual harassment, acting as a witness in a sexual harassment investigation, refusing to follow orders that would result in sexual harassment, intervening to protect others from sexual harassment or advances, or challenging an allegation of sexual harassment. If you believe you have been retaliated against, you should file a complaint with an EEO counselor within 180 days of the alleged retaliation and follow the Office of Human Rights complaint process. Note, sexual harassment officers do not handle retaliation complaints. Retaliation can include unwarranted reprimands, unfairly downgrading personnel evaluations, transfers to less desirable positions, verbal or physical abuse, altered and more inconvenient work schedules, threats to make unwarranted reports of misconduct, increased scrutiny, spreading of false rumors, and treating the associates of the employee being retaliated against negatively. Employees found to have engaged in retaliatory behavior will be disciplined up to and including termination. Module 4. Prohibited Relationships. Prohibited relationships and conduct. All employees are prohibited from engaging in dating, romantic, or sexual relationships between a supervisor and any employee within their chain of command, whether the supervision is direct, indirect, operational, or situational, with an employee and a trainee, recruit, or intern within the same agency, regardless of chain of command or assignment relative to each other, where such relationship is prohibited by professional or ethical standards such as lawyer-client, doctor-patient, or social worker-client. Employees are also prohibited from participating in matters that affect or could affect the financial interests of someone, such as an employee, contractor, grantee, client, with whom they have a dating, romantic, or sexual relationship. Employees are prohibited from engaging in sexual activity of any kind during work hours, regardless of location. And employees must disclose a relationship that may raise a charge of preferential treatment. All the above relationships are banned. If a relationship may become prohibited after a change in position or organizational structure, you are required to disclose the relationship to the agency designee for review. Preventing prohibited relationships and conduct. Each agency has appointed an agency designee who is responsible for receiving disclosures of preferential treatment and prohibited relationships. All existing relationships that are considered prohibited under the new mayor's order require immediate disclosure to the agency designee. All employees who are parties to the relationship have an independent responsibility to make the disclosure to the agency designee. The agency designee will work with the agency to put in place interim safeguards to prevent conflict of interest and preferential treatment, and work with the parties to help them come into compliance with the ban on prohibited relationships within a reasonable time frame. Ultimately, the employees who are in the relationship are directly responsible to comply with the ban on prohibited relationships and must take steps to remove their relationship from its prohibited status. This includes applying for a new job within the agency or elsewhere if necessary. Preventing prohibited relationships and conduct. Where otherwise acceptable, romantic relationships, for example, non-chain of command coworker romantic relationships, may become prohibited due to a promotion, agency reorganization, or other similar circumstances. The employees in that relationship must disclose the relationship to the agency designee as soon as either party realizes the possibility of their relationship falling into a prohibited status. The agency designee will work with the parties and agency to make appropriate adjustments to help prevent noncompliance with the policy on prohibited relationships. Ultimately, the employees who are in the relationship are directly responsible to comply with the ban on prohibited relationships and must take steps to remain in compliance with the policy. Remember, there is a ban on prohibited relationships, and you could be subject to discipline up to and including termination for engaging in one. Parties who are interested in engaging in a romantic, dating, or sexual relationship that could violate the ban must eliminate the work relationship or conflict of interest before beginning the relationship. For example, if persons in a chain of command situation wish to begin dating, one must transfer or otherwise seek employment elsewhere beforehand so that no prohibited dating relationship commences. Thank you for joining us to learn about this important topic. For more information, please consult the Mayor's Order located at dchr.dc.gov/sexual-harassment. If you have any questions, please connect with your agency general counsel or contact us at dchreemployeerelations@dc.gov. Thanks again.